Thomas, mic is on.
Very good evening to all of you. So we are medical legal team of Young Ophthalmology Society of India. Uh, we have been conducting webinars on various topics of medical legal interest, including consent, Consumer Protection Act, record keeping, indemnity insurance, how to respond to a legal notice, medical legal issues related to TAS and ENDOP, telemedicine, medical legal aspect and medical legal aspects related to cataract surgery, ROP, medical certificates, intravitreal injections, billing, mass cataract surgery, refractive surgery, National Medical Council guidelines of ophthalmologists, assault against doctors, violence against doctors, medical issues related to life surgery, and various other topics. So today is our 27th session and we will be discussing medical legal aspects of sponsorship by the trade. So from the beginning, we have been lucky to have guidance of Dr. Anand Deshpande sir. Sir is a director and eye surgeon at Guru Prasad Netra Rugnalaya at Aurangabad. Sir is chairman of Indian Medical Legal Consulting Services Private Limited. Sir is the chairman of Medical Legal Committee of All India Ophthalmology Society. Sir is a faculty of law and a visiting professor at Symbiosis Law College, Pune. Sir is the Faculty of Management Sciences, BAMU, Aurangabad. Sir has written various books like Legal Aspects in Ophthalmology, and Sir has played a pivotal role in formulating the consents which has been circulated by AIOS. We are privileged to have our mentor, Dr. Manoj Mathur sir, with us. Sir is a senior consultant in glaucoma and comprehensive ophthalmology at Swaroop Eye Center, Hyderabad. Sir is presently the honorary treasurer of All India Ophthalmology Society. Sir is past advisor and president of Telangana Ophthalmology Society and Hyderabad Ophthalmologists Association. Sir is co-chair of Health Insurance and TPA Committee of AIMS. Sir has been a member of Medical Legal and Ethics Committee of AIOS in the past. Sir has been a member of Managing Committee of AIOS and Sir has also served as a member of the Advisory Board of Indian Journal of Ophthalmology. So we are lucky to have Santosh Honavar sir with us. Sir needs no introduction. Sir is currently the Honorary General Secretary of AIOS. Sir is also the Director of Medical Services of Center for Sight Group. And Sir is the Director of Department of Ocular Oncology and Oculoplasty at Center for Sight, Hyderabad. Sir is the Director of National Retinoplasty Foundation. Sir was the editor of Indian Journal of Ophthalmology and its sister journal, Indian Journal of Ophthalmology Case Reports. So our speaker is our mentor, Dr. Prakash Marathe sir, who has been guiding us from the beginning. Sir is past president of Indian Medical Association Pune, sir, and also past president of Maharashtra Ophthalmology Society and Pune Ophthalmological Society. Sir is past senior vice president of IMA Maharashtra State. Sir is a trustee of IMA Pune and Pune Ophthalmological Society. Sir is a member of Medical Legal Committee and past managing committee member of AIOS. Sir also received BOA Gold Medal in 2024. Sir has received multiple awards, including President's Appreciation Award by National IMA Headquarters, President's IMA Maharashtra State President's Appreciation Award, President's Special Felicitation Award by IMA Maharashtra State, late Dr. Asa Kelkar Award. Sir was joint organizing secretary of World Conference of IS MSICS 2019, and Sir has participated in a mega ICAM at Kenya. Sir has presented through electronic and print media for public awareness via various media outlets, and Sir has conducted instruction course and delivered talks on medical legal practice management and small incision cataract surgery in national, state, and international conferences. Thank you, sir. So we can go directly to the presentation.
So Dr. Kaushik, before we start Marathe sir's talk, we have with us Dr. Nilesh Kumar, Secretary of YOSI. So Nilesh, would you like to say something?
Thank you, ma'am. And I would first like to congratulate Team MLC. I think Team MLC and Social Culture, these are the two teams that continued seamlessly from the last GC to this, like the last governing council and the office bearers to this seamlessly. Like there was no interruption, and they continued their activities, doing a marvelous job. And we were not sure that are there so many MLC topics to continue, but they are doing marvelous job, getting more and more topics, nuanced topics, and these are very important. Like today, I joined because this topic was so important for us to learn, and having Manoj sir, Prakash sir, and sir throughout this journey, we have gained a lot as YOSI, as young ophthalmologists, because we never thought that medical legal was so important. And really indebted to Santosh sir for joining us. Thank you, sir, for joining us today, because we will need your expertise in this topic as well. Thank you, Aarti ma'am, for calling me again. Uh, let's continue with talk.
Yeah. So over to you, Marathe sir, for your presentation.
Thank you. Thank you. Good evening, everyone. I think respected office bearers of YOSI, Dr. Nilesh Kumar, who is the secretary, Dr. Deepanshu, Dr. Kaushik, Dr. Aarti, and Dr. Riddhi. And my mentor and guide in medical legal aspects, Dr. Anant Deshpande, who is the panelist and chairperson today, along with, we are fortunate to have secretary and treasurer of AIS. This is a great opportunity for this particular session. I'm lucky to have them as chairpersons and panelists, Dr. Santosh Honawar, the great secretary of AIS, and his colleague treasurer, who is also a very good friend of mine, Dr. Manoj Chandra Mathur. I think with these words, I like to start my topic. It is a very important topic. It was very difficult for me to get my material for this particular, but I have tried. I'm trying to share my screen. Dr. Aarti, let me know what is seen on the screen now.
Yes, sir. Your slides are visible. We can just go on the slideshow mode.
Yeah. Is the slide completely seen now?
No, sir. The slideshow mode is not yet seen. Maybe, sir, we can stop the screen share once. You can open your presentation in the slideshow mode and then share.
Okay. Now?
So you need to share the screen, I think.
Now what is seen? Hello, is the slide seen now?
The slides are seen, but they are still not in the slideshow mode.
Now?
Not yet, sir.
Doctor, you can stop sharing the screen, and while doing the share screen, no, doctor,
Now?
can you stop? No, doctor, you may have to stop this sharing now.
Yeah, I have stopped it. Okay.
Now, while you start sharing screen again, you'll see two thumbnails. One is the PPT in draft mode, and the other one is the presentation mode. Just choose the other presentation mode, the full screen mode.
Now?
Yes.
Yeah, you can go ahead, doctor.
Yeah. So thank you, YOSI, for the opportunity. So there are no financial disclosures. For this particular presentation, which is very difficult, I have taken help of my senior colleague, who is Dr. Jayan Navarange from IMA. He's MBBS, MD Pediatrics, DCH, and LLB. He's a medical legal expert and consultant. He's senior pediatrician and lawyer in Pune. Actually, at present, he is in America, and he has helped me a lot for this particular presentation. He's my leader and friend philosopher guide at Indian Medical Association. So acknowledgement by his name is must for this particular presentation. So as you know, the topic's name is medical legal aspects of sponsorship by the trade. So why the issue? There are like allegations, NGOs and government, etc. As per findings published by JAMA Internal Medicine, even a free visa can influence a doctor's prescription. In recent past, the maker of Dolo 650, a painkiller, was alleged to have distributed freebies worth 1,000 crore, approximately 120 million US dollars, to doctors in exchange for doctors prescribing this medicine. And this results in tax evasion by companies claiming it to be tax deductible. For example, in its 2019-20 report, the Public Accounts Committee noted that tax assessing officers in 7 Indian states had allowed as tax deductible expenses incurred by companies towards gifts and freebies to doctors, resulting in a loss to the tune of INR 55.1 crore to government revenue. Am I audible?
Yes, sir, very well.
Also, under the guise of self-promotion, direct and indirect benefits are offered to doctors, including actual gifts, freebies, sponsored foreign trips, hospitality, and honorary positions. There exists criticism of it being akin to bribing, greasing hands, etc., and it's alleged since long. This affects the prescription habits of doctors and can result in the prescription of drugs at higher doses or numbers, or for a period longer than required, in irrational combinations, or of overpriced brands or inappropriate uncalled medication. All these lead to patients suffering by high costs plus unnecessary medications, investigations, procedures, etc. India has many laws to regulate drugs, devices, advertising, and marketing by companies to end consumers. That includes Drugs and Cosmetics Act 1940, Drugs and Magic Remedies Act 1954, Consumer Protection Act 1986, and then revised in 2019, Advertising Standards Council of India's Code for Self-Regulation in Advertising, Guidelines for Prevention of Misleading Advertisements and Endorsements for Misleading Advertisements 2022, plus Indian Medical Council Professional Conduct, Etiquette and Ethics Regulations 2002, and adopted by NMC 2023, but it had no power to control or penalize the companies. Now, UCPMP 2014, and now it is converted to UCPMP 2024. What is UCPMP? It is Universal Code for Pharmaceutical Marketing Practices, which has full control over drug and or device companies. Voluntary as of now. So, number MMC 211-1, 2009 Ethics, 55-667. Through this amendment in December 2009, the then Medical Council of India added the following clause 6.7 in original MCI regulations on ethics, and as its same carried forward, ditto by National Medical Commission. 6.8 Code of Conduct for Doctors and Professional Association of Doctors in their relationship with pharmaceutical and allied health sector industry. Then 6.81 in dealing with pharmaceutical and allied health sector industry, RMP shall follow the stipulations given below. The first one is gifts. A medical practitioner shall not receive any gift from any pharma or allied industry and their salespeople or representatives. Travel facilities. A medical practitioner shall not accept any travel facility inside the country or outside, including rail, air, ship, cruise tickets, paid vacations, etc., from any pharma, etc., for self and family members for vacation or for attending conferences, seminars, workshops, CME programs, etc., as a delegate. Now, here is a trick. What is that? So, not for faculty. So, it is allowed for faculty. So, hospitality. RMP shall not accept individually any hospitality like hotel accommodation for self and family members under any pretext. Cash or monetary grants. RMP shall not receive any cash or monetary grants from any pharmaceutical and allied healthcare industry for individual purpose in individual capacity under any pretext. Funding for medical research, study, etc. can only be received through approved institutions by modalities laid down by law, rules, guidelines adopted by such approved institutions in a transparent manner. Medical research. RMP may carry out or participate in work in research projects funded by pharma, etc., but after fulfilling the following. What is that? Being proper and ethical, RMP shall ensure that the research proposal has permission from the competent concerned authorities. Such a research project has the clearance of national, state, institutional ethics committees. It fulfills all the legal requirements prescribed for medical research. Source and amount of funding is publicly disclosed at the beginning itself. Proper care and facilities are provided to human volunteers if they are necessary for the research projects. Under animal experimentations are not done, and if necessary, they are done in a scientific and a human way. While accepting such assignment, RMP shall have the freedom to publish the results of the research in the greater interest of the society by inserting such a clause in the MOU or any other document or agreement assignment. Maintaining professional autonomy, RMP shall ensure to never have any compromise either with his or her own professional autonomy or freedom as well as of the medical institution. Affiliation. RMP may work for pharma, etc. in advisory capacities, as consultants, as researchers, as teaching doctors, or in any other professional capacity. But in doing so, he shall always ensure that his professional integrity and freedom are maintained. Patients' interests are not compromised in any way. Such affiliations are within the law, fully transparent and disclosed. Endorsement. RMP shall not endorse a drug or a product of the industry publicly. Study results of efficacy, safety, etc. of such products shall be presented to and or through appropriate scientific bodies or published in appropriate scientific journals in a proper manner. In a nutshell, these new regulations ensure patients' interests at the top, along with ensuring ethical behavior from RMPs in all respects. So faculty is exempted. Remember this. So for delegates, it is a little different, but faculty, they are exempted. And one more thing, everything is for society and patients and less for doctors. That is the trick here. So UCPMP 2024, what is UCPMP? I have told you just now, Universal Code of Pharmaceutical Marketing Practices. At the very outset, the UCPMP 2024 demands strict compliance from pharmaceutical associations and its constituent companies. The key points are the scope. UCPMP 2024 clarifies that it applies to both drugs as well as medical devices, and it covers companies and entities manufacturing or dealing with the sale and distribution of such products. Brand reminders. It permits brand reminders in two categories. First one, informational and educational items, that is IEI, including books, calendars, diaries up to ₹1,000, that is so bigger. Free samples provided by companies to medical professionals, these free samples, with some restrictions like the values will not exceed 2% of domestic sales of that product per year. No offer any gifts, pecuniary advantages, or benefits in kind to healthcare professionals or their families. Travel restrictions. Sponsoring travel and accommodation for the doctors to attend the conferences or workshops is prohibited. Again, there is a trick here, unless they are invited as speakers. So for speakers and faculty, there is exception. So UCPMP 2024, it is most important for us as healthcare practitioners and organizers and associations. Continuing medical education, a new provision regulating engagements between the pharmaceutical industry and healthcare professionals for CMEs, CPDs, conferences, seminars, workshops, etc. It provides a framework for activities or events as follows. The first one is conducting events in foreign locations is strictly prohibited. Companies to share event details and expenditures on their website, and these should be subject to independent audits. Organizers must also disclose participant and speaker selection procedures, funding sources, and expenditures on their website, and these should also be subject to special audits. All entities involved must comply with the relevant provisions of the Act. Support for research. A new provision providing guidelines for collaboration between companies and healthcare professionals. So in brief, what is that? Any research must have approval from competent authorities and be conducted at recognized locations. Engagement of healthcare profession in a consultant advisory capacity must be for bona fide research services under a consultancy agreement involving a consultancy fee or an honorarium-based payment subject to compliance with all applicable tax laws, and expenditure by companies on research is considered allowable subject to provisions of the Act. Ethics Committee for Pharma Marketing Practices. Like its earlier counterpart, the UCPMP 2024 provides that each association of pharma and/or device companies will have a committee for handling complaints, namely the Ethics Committee for Pharma Marketing Practices. It is called as ECPMP. Lodging complaints, penalties, appeals, miscellaneous, all are defined. UCPMP 2024 to be implemented through Ethics Committee of Associations of Pharma Companies, even for non-affiliated manufacturers. And this is by Mazumdar and Partners Law Firm on 5th June 2024. So counter agreements to what JAMA, government and NGOs feel. No other country has imposed such a stringent ban, which other countries opting instead for regulated transparency. It is prudent for a doctor to choose the medications they advise wisely, valuing effectiveness, appropriateness, and affordability rather than any other factors. Will a doctor choose substandard, inappropriate drugs and allow loss of patient or trust just to have some monetary gains from gifts, sponsorships, etc.? Not at all. Will the doctor get sold out? Not at all. This is doubting integrity of medical profession and doctors. Are the current regulations not enough to control healthcare professionals' ethical behavior? Are CME's conferences required? Yes, of course they are required. For updating and in turn benefit of patients and the society. This is accepted by all medical councils as seen from compulsion of CME points. If sponsorships are prohibited totally, they would become very expensive, in turn increasing the cost to the patient care. Don't pharmas have right of advertising to RMPs about safety, new drugs, etc.? They are banned to advertise to laymen, accepted. But why not RMPs? How they will come to know of their availability of their products like drugs and instruments and equipments, etc.? So in France, USA, Canada, Australia, United Kingdom, then EU, there are regulations for sponsorship about CMEs, etc. We generally aim to ensure that medical education remains independent and free from undue influence by the pharmaceutical industry while still allowing for sponsorship. Law banning pharma and manufacturers of medical devices from sponsoring any CMEs, medical conferences as notified in the NMC regulations of August 2023 and later taken back to generalized resistance from IMA and various medical bodies will be a disservice to society. If you remember, there was what? No CMEs or conferences would have been possible without that. 8th point is we must learn from other nations in having laws that ensures transparency and eliminates bias rather than outright banning sponsorships. The way forward is collective progress, taking along all stakeholders and ensuring the sanctity of the profession, associations and healthcare is maintained without hindering the massive progress Indian healthcare is making. So what we should be doing? Follow NMC regulations 6.8.3, which mean as follows. As an individual doctor, one can accept freebies gift up to rupees 1,000. In an occasional income tax cases, it has been held that this will be added to your income, even if you don't receive cash, but only in kind, and valuation will be done by the department. You can accept free sample of a drug. As a faculty, your travel expense, accommodation, consultation fees, etc. are allowed. This is a very important point, but not as a delegate. as on today. No foreign travel in any circumstances as per UCPMP, even up as a faculty. See, this is a different thing. Foreign travel is not allowed even as a faculty, but what Dr. Navrenge said, it is not yet clear whether it is acceptable for the faculty or not. It is not yet clearly written. MCI, state medical councils, National Medical Commission have taken action against doctors violating these rules time and again. An action of warning or temporary suspension of registration have resulted sometimes. Mass action also been done. Mind well that courts give no relief in such matters against decisions of medical councils in any situations. What you should be doing as an office bearer of medical organizations like AIOS, IMA, MOS, various state organizations, or of the conference or update workshop. Follow the guidelines of UCPMP strictly and take sponsorship for an approved program or research. Best is to take state medical council's approval for credit hours or credit points. That will make the situation easy. Publication of accounts, etc. on the portal of the website for UCPMP is the responsibility of the pharma or device manufacturer, but as stipulated, have a MOU or at least an email confirmation of sponsorship or so-called academic grant and the purpose. In a nutshell, account of such funds and purpose have to be transparent and not for any individual's advantage. Finally, it's important to note that UCPMP 2024 is a voluntary standard not enforceable by any law as of today. This is very important sentence. UCPMP is there, but it is not enforceable by any law as of today till January 2025. That's why Federation of MRs has put in a writ in Supreme Court asking legally enforceable UCPMP and has described this as old wine of 2014 in new bottle of 2024. Decision of Supreme Court is not yet come to hearing stage. However, it is better to be prepared from now on, as at present its implementation is voluntary and through level of associations of pharma and device companies and through their respective ethics committees. In short, what's binding on us are Medical Council of India in the past, and now it is called as National Medical Commission Rules 6.8.3. The Apex Committee for Pharma Marketing Practices under the Ministry of Chemicals and Fertilizers recently in November 2024 found pharmaceutical company, that is Avil Healthcare India Private Limited, a subsidiary, this is about a case, a subsidiary of the US-based Avil is guilty of sponsoring international trips to the tune of nearly 1.91 crore for 30 doctors, a breach of the Uniform Code of Pharmaceutical Marketing Practices, that is UCPMP 2024. The case came to light based on an anonymous complaint accompanied by documents supporting the claims concerning unethical marketing practices where doctors were offered the freebie for professional development. The tip-off gave details about the travel tickets and hotel accommodation offered to doctors under the guise of a conference, the Aesthetic and Anti-Aging Medicine World Congress 2024 in Monaco and Paris, said the Union Health Ministry. So this is a recorded case. So Dolo promotion, as I have just now talked, case referred to earlier. FMRAI, that is Federation of Medical Representatives Associations of India versus Government of India, writ petition in Supreme Court for making the UCPMP 2014 and now it is 2024 enforceable legally and not voluntarily. So issue is seeking to make UCPMP a statutory law with enforceable penalties. Current status of the case, Supreme Court has taken a note of the petition and is considering the matter. So these are various references for this particular talk. I know the talk was little complicated. Thank you everyone for giving me the opportunity and for the patient hearing. So I think with this, I think I have tried to make the topic little simpler. So medical legal language, legal references were there. It is very difficult to understand. I know experts are there like Dr. Deshpande sir, Dr. Mathur sir, and Dr. Honavar sir. So let us take it forward. Thank you so much.
Thank you so much, Marathe sir. This topic was really not very easy, but I think we got a fair idea after your talk. So let's hear from our panelists their view on this topic before we go on to the question answer session. So let's start with Anandesh Pandey sir. Sir, would you like to add something or comment something about the presentation?
Yes, actually the speaking, when the case was lodged by IMA and representation was done by so many associations, the amendment which was taken on 23rd, that is in 23rd July, was taken back, and the Supreme Court given that it should be stopped. So what should be then available? So they said that the ethics of 2012 12 will be continued, and as such the ethics of 2012 was there, and the same ethics will continue till further order. So at present the amendments are totally gone, and the previous what was there in the medical ethics, the same is continued. And for that purposes, in between there was a confusion whether to take the conferences or not. And in that, with this Supreme Court decision, it was very clear that you can have the conferences, you can have sponsorships within the limits, and what Dr. Marathe has said very nicely cleared the confusions and so many things. But at present, we are there as we were in 2012.
Mathur sir, would you like to add something?
Yeah, like it was very enlightening talk by Dr. Marathi sir, like very nicely enumerated. And as Dr. Deshpande sir said, the proposed changes in 2024 are currently on the back stage, and then the ethics rules of 2014 are enforceable as of now. We need to understand the clear-cut distinction between an individual, a faculty as a delegate, individual as faculty, and association. So the rules applicable are totally different. For an individual, all these changes, like especially hospitality, sponsorships, and all those are applicable. But as faculty means a faculty has to sign a contract with the company as an expert speaker, and for that, travel, accommodation, and remuneration are permitted. Whereas the rules are totally different for a society. The difference between a delegate, faculty, and the society is a company has a right to market its products, and a society has a right to hold conferences. What the company is doing for the society, the sponsorship amount that they are paying is in lieu of putting up a trade stall, which is permissible. So a society can certainly organize a conference, can certainly solicit trade, and so companies have a right. They can put up their stalls, market their products for the benefit of the faculty and the delegates. So that clear-cut distinction has to be seen. And as Dr. Marathe said, that the faculty travel overseas is shady. Like it is still not clear whether, like an international speaker, for example, like a top Indian doctor, has every right to travel to a foreign country or a third world country to disseminate the knowledge about a particular disease and a particular product. So I think there should not be a restriction. That's why probably legally a loophole has been created, and it is not very clear. But I'm certain, like for faculty travel overseas also should not be an issue at all.
Correct.
So let's hear from Santosh Honawar sir about this topic.
I think it was a very nice talk, comprehensive. Dr. Marathe, very nice. So, in a conference that is held by the society, there are two aspects. One is trade exhibition. Second is sponsorship of scientific sessions. Trade exhibition is a commercial venture because we pay GST on it. Like you provide space for exhibition and you get fee for it. So there is absolutely no controversy about companies participating in trade exhibition and paying the appropriate fee. On top of that, if a company wants to participate in a scientific session or wants to sponsor a scientific session, then the rules are very clear. that the company is not supposed to suggest topics.
Hmm.
They should not be part of the designing
वो
of
तो
the
हो गया वो
scientific
सब तो
program. That is
पूछेंगे
very
तो बता देना यार देख के
so
बाद बता देना
they should
नहीं
be
पूछेंगे
provided an opportunity to sponsor a scientific session which may be relevant to the interests of the company, but at the same time, they cannot guide the deliberations of the scientific program. So that the scientific committee actually takes care of. If a particular company is interested in sponsoring a session, the session is named after that company, but the deliberations are totally under the control of the scientific committee. With that, again, there is no controversy. About sponsorship of faculty, it is very clear that anybody who has a talk or any speaker can be sponsored, including free paper presenters. So that means that even postgraduate students who have a free paper presentation or a poster presentation, any sort of scientific presentation can get travel sponsorship. It's very clear, absolutely no controversy. About international trips, again, the loophole has been left there. International speakers can be brought by companies, and Indian speakers can go internationally and present their work with sponsorship. There is nothing to bar it at this point in time. There are no clear rules as it is already enumerated, and there are no restrictions as well. So it is taken as something that is permitted.
Okay, sir. So let's move on to a few questions which we have. So Dr. Nilesh Kumar has a question. Sponsored talks on new drugs. How are they
No,
legal?
no. One thing, Arthi, one thing I have to clear here.
Yes.
About the thing, the Supreme Court has given the decision that the ethics rules which were there in the past, that is the year they have
2012.
put it, will remain in force and all will be not taken into consideration. In that rule, there is nowhere written that the international faculty charges should not be charged or should not be sponsored. So naturally, international faculty charges can be charged and can be given. It is not unethical or not illegal. So international tours for faculty is not illegal. Okay? Yes,
Okay, sir.
continue.
Yeah. So the question is that are the sponsored talks on new drugs legal? And the second part of this question is live surgery to demonstrate the intraocular lenses. Are they also legally allowed? So maybe Santosh and our sir, you can start your comments and then we can
Right.
move on to
So any talk is allowed as long as the talk title is not suggested by the company, or the speaker is not given a talk title. They can select a speaker, they can nominate somebody to represent their company, who can be on the board of the company, or who can be an advisor to the company, who can be a product developer for the company. But at the same time, they're not supposed to suggest the talk title. The talk title has to be suggested by somebody who designs the program, and the company should not have any participation or any role in designing the program. So if there is no such watertight compartment, actually some communication does happen between the person who organizes the scientific program and the company which sponsors it. But as per rules, it should be a watertight compartment. And as far as live surgery is concerned, it is sub judice. The matter is under consideration of the Supreme Court. Couple of hearings have taken place, and last heard, the National Medical Commission has advised the ethics committee of NMC to go through this issue and provide guidelines, but that has not happened. So Supreme Court case is still pending and hearings are going on.
I think the question, first question was, suppose the company has come out with the new product. There is trade name and generic name. While delivering a talk in the scientific session, the speaker speaks about that product, but the company wants to project their trade name. So how that is tackled?
Trade name, as see, you can, there is no, at least at this point in time, there is no bar on projecting trade names. In fact, even in publications, if you used a particular drug, within parentheses, you are supposed to mention the name of the drug that has been used, the product, and the company and the location of the company. So that is permitted. But at the same time, if a person who is speaking is involved in some commercial aspect of that particular drug, there has to be a declaration in the first slide itself. All conflicts of interest have to be declared. Once the conflict of interest is declared, if I am speaking on a particular drug, I say very clearly that I have a conflict of interest because I get royalty from this company or I'm a paid consultant of this company. Then the audience are free to make their, decision based on my talk as well as my disclosure. So if I don't disclose, then that is unethical.
I think when the research grant is being given by various companies, I think in my talk it was pretty clear that particular new product, and if the relation of that product with the research is being done by that person, I think it should be allowed. And it's
one of
completely
CME is
straightforward.
also,
Yes.
one of CME is the difference between a conference where the scientific committee is responsible for organizing the topics and that is there. But the companies as a single CME speaker, they are entitled to do that, and we have been doing it. Like we have to sign a contract with the company, but in the presentation, what we do is generally we take the molecule name and not the trade name throughout our talk. But the last slide can be the second slide. We say that this session is sponsored by so and so company, and we acknowledge their support. And we talk about the disease, we talk about the product as a generic in generic terms. But in the last slide, we can put up a brand slide and say that this is again thanking the company. This is the trade. So that is commonly accepted, and we do sign a contract for remuneration, for travel, and for accommodation. That is permitted.
Perfect. Company has the total right to present their products to the medical profession because they cannot do that with the lay person. So it is the medical fraternity to which they have to present, and that's the only way which is legally acceptable.
Dr. Kaushik, over to you for you have a question.
Sir, my question was like if a person is receiving travel award or travel allowance by a national body, suppose AIOS, which is known to be sponsored by a pharma company. So what is the legal responsibility of the awardee, the person who is getting the, is there any thing involved?
No, not really, because whenever company gives any money for any award to AIOS, it is an unrestricted educational grant. AIOS signs contract as an unrestricted educational grant, which can be used for any purpose, including travel grant, quiz prizes, etc. So the recipient has no legal binding.
In my talk, what I said, most of the rules and regulations are for doctors and companies, pharma companies, as well as instrument and equipment companies. They are in favor of society and patients, but very much less for doctors. So that way, should we try as organizations to ask for some changes in these rules and regulations from our side to the government? If some clarification is needed, or whatever is there is fine.
I think 2012 guidelines are fine because the latest one which was withdrawn was very restrictive. It in fact restricted CME activities as well, which goes against the NMC's own criteria that everybody should have CME credit points to even renew their membership. So obviously that is contradictory, and that is something that is very restrictive, and that is rightfully has been disallowed in the sense that it has been kept under suspension. Government might be working on changing those rules or modifying those rules. We don't know what is happening in the background, but definitely right now it is under suspension.
We were vigilant. We were vigilant as various bodies,
Right.
like Ophthalmic Association,
but what
IMS.
currently exists,
because of that, they had to take it back. Otherwise, they were trying to enforce it. Yeah, please continue.
So what is happening currently, I think, is a win-win situation because it's not so restrictive. And it is expected that companies should not sponsor somebody who's not a speaker, who's just a delegate, and not indulge in sponsoring foreign trips for families, etc. Which is, I think, which even the patients would want that to happen. Otherwise, we will look very unethical as a group. If we try to fight for those rights, which obviously are unethical, which are obviously in bad taste. So I think the current situation is absolutely fine.
Sir, my question is,
one point was like the emphasis was laid on the current regulations on food. Like no doctor should, during the CMEs or conferences, free food should not be given. So the caveat here is like there should be, even if it is a CME organized by somebody, there should be some minimum registration fee to cover the food aspects. So that is one technical aspect that needs to be looked into, not very clear as of now. But if this clause is implemented, probably free CMEs will be out.
It's not implemented anyway, so.
Not implemented.
Sir, if a doctor has any patent or like any commercial interest, financial interest, or he is a consultant, or he has been supported as a faculty or guest speaker somewhere else, does he need to legally mention that in their prescription? Not like how should they go about their prescription, or when they're seeing a patient or treating a patient? Is there any guidelines or anything which he should follow?
No, you don't have to disclose any of your conflict of interest to the patient. There is no rule binding us. Even in most advanced countries, there is no such rule. But if you have a website of your own, which guides or directs patients, or referrals to you, in that situation, in the website, you're supposed to have all the disclosures, not in your prescription. But if you don't indulge in advertisement either through electronic media or through websites or any of those sort, then you're not supposed to mention. There is no rule to say that you're supposed to mention any of this.
Sir, also in USA there is a system like CMS or something in which all healthcare providers, they are listed there, and if you search their name, they will be giving like every yearly how much they are compensated for their consultancy or anything like that. And also the pharma companies, they have the list. There is a public list of the people who they actually sponsor or who are taking grants from them for their research works or consultancy or other. Yeah, so does India in any way have such a system?
We don't have such a system at all. In there, what they do, they have a unique identification number for every doctor. And whenever a company sponsors a doctor for anything for that matter, including travel, accommodation, registration fee, or gives a grant, they're supposed to file the unique identification number of the doctor along with the amount of money that has been given to the doctor. So that gets populated in the doctor's database as well as in the company's database. So when you search such a database, we'll know actually how much money each doctor has got and how much money each company has given, which is a very transparent system, which is accessible to public. Even people from other countries or patients themselves can search and find out. Such a system does not exist.
That is the prospective system that is going to happen in India with the NMC number in future. And as far as these remunerations and the kind of things that consultants get in India is recorded, and that reflects in your personal 26AS, whatever grants. It's so the government, the income tax department does have the knowledge of a particular doctor getting remuneration from the companies. It gets automatically tabulated in the 26AS form, but not for public, not for patients as
It
of
is
now.
already happening because you're going to give your PAN number whenever you get a grant.
Yes.
Even if you sign a contract for us as a speaker with a company for a local CME, which may happen at the district level, you still sign a contract and the company will have your PAN number, and that automatically gets reflected in your income tax data. That is already happening. Even if you get some travel funding, that shows up as your income. In fact, you're supposed to pay tax on it.
Here I remember one thing about All India Ophthalmological Society. Whenever the scientific committee gives invitation to all the speakers, what they expect that the second slide of each and every presentation should say about financial disclosure.
Yes.
Whether it's none or whatever it may be.
Yes.
So that is a very good system that way, whosoever presents that particular topic, whether he has got financial interest or not. So that clearly tells to the audience whether this particular speaker talking about this particular drug or this particular equipment has got financial disclosure about that product or not.
Yeah.
So that is a very good system, I should say.
And also the consultancy charges or the professional charges which the faculty receives, they are like charged, I think 10% TDS on that by like professional tax, which is already submitted in the treasury, and also the consultant who is receiving that, they are bound to pay tax on the like money received, which is
TDS is already there, and you will be taxed according to the slab that you belong to. There is no exemption for this. Unless you have used that money for research purposes for which you can claim as expenditure.
If there are no questions, I can just ask one thing because Dr. Santosh Anavarji is the researcher. Most of the companies or most of the countries for various research projects, they get a very good grant. That particular amount of grant is person oriented, institute oriented, research oriented, and whenever that grant is little more than your research cost, little less than your research cost, if there is some excess amount, little bit you can throw the light on this particular topic.
It is all, sir. In fact, it is project oriented. It is sometimes the researchers get a grant on their name. Sometimes it is lab oriented. A group of researchers will get a grant. Many times it is institute oriented, and many times it could be for a multicentric study, which will be run by a group of individuals across different institutes. So there are various types of grants, and grants always make some small profit for the researcher, the group involved, and the university and the hospital. That's because they use this money as buffer money to start a research idea or incubate a research project. It is not just sufficient, but it is definitely more than what is sufficient, because that amount of money is required for the researcher to initiate a de novo project until he or she gets funding for that particular project. So it is always profitable, and in fact they can employ certain research assistants with that money, sometimes research fellows, sometimes even co-faculty, sometimes they can get equipment for the lab. So it is a global and quite open kind of a grant system that they have. Even in India, when we get a grant, there is no restriction as to how you want to use that grant. Of course, you have to use it for the research project, but rest of the money you can use it for your own research purposes, but not for personal use. Unless you have such an agreement with the institute that so much percentage of the research grant should come to you as a personal incentive, you can't use it for personal incentives.
Now, there are two types of researchers. One is related to the company and trying to develop a new drug or new equipment. That research is in relation to the company. Or one researcher wants to do something not related to company, but some experiment of his own, like Madame Marie Curie and that her research, independent research. So suppose that type of research any ophthalmologist wants to do, not in relation to company, then he can also get the grant for various associations and bodies.
Absolutely. There are open grants, there are open grants, there are organizational grants like ICMR, DBT, DST, INSA, they all give grants for projects. Similarly, companies like, there are many companies. Santen used to give research grants. There are many companies which can give research grants to individual and institutes.
I think that is the great feedback from your side. What foreign countries they have been doing, Europe, Australia, America, and they are having their practice. We had Dr. Dua's place at Nottingham. I think half of their time is devoted to research, more than half. Here in India, we see most of the times the patients, we do surgeries, but maybe in research we are lagging behind, though there are talented people in India. So I think our system should be such that we should devote our time at least as maximum, not to every time is devoted to the patient, but for research. I think young generation who is talented should devote their time to, like Narayan Netral has been doing, or CFS is doing, or so many big associations they have been doing. Like some funds they must reserve for their research project, and same way the young talent of India, they should devote themselves in research.
So is time compensation permitted for the researcher from the research grant?
Yep. It is permitted. In fact, you can get 80% of your salary from your organization and 20% from the research grant if you give 20% of time for research. Similarly, it can be proportion 50-50, 30-70, whatever proportion. So if you do 2 days of clinical work and 4 days of research, 1/3 of your salary can come from the institute and 2/3 can come from the research grant.
So since we have some 5 minutes, there is one more question by Nilesh Kumar. If company sponsors open access to some article discussing their product, what is author's responsibility legally?
Company cannot do it without the publisher's agreement. Company enters into an agreement with the publisher. And once you have published an article, the copyright always lies with the publisher. Correct. So publisher has a legal binding to the author only to the extent that the article is published correctly. Beyond that, he can sell your publication to anybody for making profit. Publishers are for profit and they can sell your article for open access to a company and you have no right over it, nor can you deny it. Because you have given the copyright over to the publisher already by agreeing to publish in the journal.
Dr. Dipanshu, you have a question?
Yeah. So we now we talked about like individual grants and individual sponsorships. So is there any regulation for for the companies and societies on national, state, or like district levels? We keep organizing a lot of CMEs these days. Like at district level, also monthly CMEs are being getting organized these days. So is there any regulation or a limit that has been set or some guidelines on that? Nothing.
No limit has been set. No limit has been set for CMEs in terms of numbers or the amount of sponsorship that is admissible to each of these. So that is actually a good situation where you can get sponsorship for your CME activities without any ceiling or restriction. But companies have to show it in their audits currently that, and also they're supposed to put up in their on their website. And now there is a new guideline for institutes also or organizations also, like AIOS at the end of the year is supposed to put their audited reports on the website for everybody to see as to how much money each company gave. We are supposed to make our audited reports public because we are a society.
Thank you.
So we are discussing that what is legally allowed and what is not legally allowed. Let's say supposingly I have done something which is not legally allowed. So who can lodge a complaint against me, or let's say whom against whom that complaint can be lodged? Can that be against the company or me, and where that can be lodged, and who is going to lodge that?
Anybody can lodge a complaint. It could be an anonymous complaint also. Against doctors, it has to be National Medical Commission or the State Medical Commission or the institution in which you're working or the university which you're an employee of. These are all the modes of, because some of these are at the level of ethics, some of these are at the level of dishonesty. So depending on what they're looking for and what is the kind of breach in conduct that the person has committed, they can lodge a complaint anywhere. As far as the industry is concerned, they have a code of conduct which, as Dr. Marathe has very clearly said, is not legally enforceable at this point in time. It is currently a voluntary code of conduct, but they can be caught if they're violating it, not for violating that particular rule, but for violating certain rules of the, say, Income Tax Act, for not disclosing that amount as having been spent in a particular manner or claiming it as a tax deductible amount while it has been used for a different purpose. So those are the ways in which an industry can be punished, not for giving money or not for not disclosing it. Understand? But as an individual, you can be punished by withdrawal of your registration for the NMC or State Medical Council for a particular duration of time. You can be suspended if you are found to be violating certain guidelines, ethics guidelines.
So this question is probably to all the panelists. So have been there have been any case where a doctor has been punished, or let's say, so Santosh Anar sir is nodding, so there has been cases
There
like
have
that.
been cases where doctors have been suspended or with kind of denotified from the registry for a finite period of time. Most of these have involved not conferences to my knowledge, but misappropriation of research fund and illegal advertisements, soliciting patients regarding that. There are very clear rules in the NMC, but it does not pertain to this particular topic at all today. And I think we should have one more lecture from an eminent personality where all the NMC rules which bind doctors to ethical practices have to be discussed very clearly. Anybody can be punished if you send a kind of say a brochure to your colleagues, soliciting patients, that is unethical except under certain circumstances. When you're starting your practice or when you're changing your practice location, then only you can advertise, otherwise you can't. Even putting up things in social media was barred by the new rules, but fortunately it's been suspended.
One more important thing I like to add here.
Hmm.
At Medical Council, like Maharashtra Medical Council, or for that matter, Medical Council of India, now NMC, doctors are registered and not the hospitals. So probably they are taking that liberty, like big hospitals and institutions where doctor's name is not there. So indirectly they can advertise. So they have got that advantage. Because suppose there is a complaint, it is not a complaint against that doctor, it is a complaint against the institution, but the institution is not registered under Medical Council.
Yeah.
So that is a loophole nowadays.
That is
people are
not a
taking
loophole
advantage.
actually. Only the hospitals or the doctors who are registered under the NMC, they are under NMC, and NMC has the right to take action on them only. But when the corporate hospital or a trust hospital or a cooperative hospital are registered under their registration, that is Cooperative Society Act, corporate hospital in corporate law, so they cannot have any action or anything to do with that hospital, or so they cannot take the actions on these type of the hospitals. The reason is behind that they are not registered with the NMC or State Medical Council.
NMC
correct.
can take action only against individual doctors who are registered with the NMC.
Suppose XYZ doctor is there, so by his name the advertisement is not going. But suppose it is XYZ hospital, and if the advertisement is in that name of hospital, probably the doctor is escaping and he is taking advantage of that and doing that advertisement in the hospital's name.
That is permissible.
The
Yeah.
company is not, the hospital is not prohibited from doing the marketing,
Correct.
doing the advertisement, because the Supreme Court judgment is that the medical profession is an industry. And whenever they are registered under the corporate law, they are the medical industry, and that is not a medical profession. Another thing is that in that marketing or in the advertisement, doctor's name can be there only to show his timing, his degrees, or his ability, but nothing more than that, so that the patient can know and can go to that hospital to have his consultation or his services. But nothing more than that should be there in the advertisement. So you can write on the advertisement that such and such doctor is visiting on such and such day at such and such time. So that is allowed. But you cannot write anything more about that doctor.
You can mention his specialty and qualifications.
Yeah, you can mention his specialty. You can mention his experience, at least in short, that he is experienced doctor. That's all. He is not junior. But you cannot say that he is a very good doctor. He has done so many surgeries. He has done this thing, that thing. That you cannot say.
Sir, one more thing, like in the past, it was doctor-patient relationship. Now with the Consumer Protection Act, the patient is the consumer and doctor and medical profession is treated as industry. So if you are not doctor-patient, if you are a consumer and industry, they are allowed to do advertising. So it is said, and it is the thinking of medical profession. So little bit ethical marketing should be allowed to medical profession. If consumer and industry relation has been put, then you cannot expect everything from the doctors the same way which was there in the past when the consumer protection law is applicable. So ethical marketing should be allowed. That is a demand from various associations and doctors now. Even medical council should think from that point of view. Like suppose the clinic or hospital is on the third floor. You cannot expect the same size of board which is there on the ground floor. So third floor has to be a little bigger than that, like that.
Even NMC or the State Medical Council doesn't look like all these things very seriously, practically speaking.
Yeah.
The advertisements which are there, which are bogus advertisements, they are taken care of. Suppose you are saying that I am a heart surgeon and somebody is coming to your hospital and doing the heart surgery. That is a bogus advertisement, and that is taken into the consideration, and that is taken into the matter. And maybe because there is a central authority in the Consumer Protection Act now newly introduced, and they have that authority to inquire, go in detail, get the information, and put a case through a collector.
But the problem is now we are ethical medical practitioners, but there are quacks and various people in the country, those who are not registered under any medical council, they can do any damn thing, all sort of advertisements, all unethical practices,
They can do
all
anything
recommendation of their
because
drug. Bogus doctors also are there.
But they can be taken to task because it is illegal. Their practice is illegal. If they are not registered with NMC, their practice is illegal. So they come under section of law.
if you inform to the police that such and such is doing the practice without the registration, the police has to take the action. If they don't take the action, you can go to the collector or commissioner of the revenue and ask them. So
they
cannot practice legally.
Yeah, so they can be taken action on from a BNS aspect, Bharatiya Nyaya Samhita aspect, but not
council,
from
not medical
council or
not
anything.
through medical council. Yes.
Not through medical council. Then
That's what
through
the
the
organizations are doing
criminal
about
law.
quackery and all.
Criminal law.
Quackery
Through criminal law.
They can be sued.
FIR to be lodged
under BNS, but not through NMC, not through IMA.
IMA
Yes.
can't do anything. IMA can lodge a complaint.
IMA has no biting teeth. No biting teeth.
Correct.
Cannot take any action.
So I think we've overshoot the time. It's 10:07. So with the permission of our panelist, Dr. Kaushik, do we have anything else, or should I give vote of thanks?
No, I think we're done. Very nice discussion we had.
So I would, on behalf of YOSI, I would like to thank all our panelists, Dr. Anandesh Pandey sir, Dr. Mathur sir, and Dr. Santosh Honavar sir, for their valuable inputs, and Dr. Prakash Marathe sir for the lovely presentation. I would like to thank Manjula and Mr. Sai for their technical support and for being with us for all our sessions. So we'll have our next session next month, and soon we will announce the topic and the date. So thank you everyone, and good night.